today
Oh,
for
okay,
new trials.
all right.
And I apologize for not having a colleague of mine is actually in trial and
See, that is so nice. They
I
didn't
feel
bring,
really weird.
yeah, they didn't bring it. See, Karen, this is what I'm talking about. Victoria, she's not wearing a jacket. You know why? Because there is somebody else in a jury trial, another attorney who didn't have a jacket and she gave it to them.
Tracy got called up in the 186 and she didn't have a jacket. You take my jacket, I'm burning up.
Oh,
Really? It's okay. But judge knows why.
no, I understand.
I just thought she's just a rebel.
Hello, morning.
Got an email from Ms. Ferguson. I was supposed to be here at 9 on the motion for continuance, the unopposed one.
Yes, because I have to put those on the record.
Okay.
See, everybody thinks those don't have to be on the record, but they do. And even when it's unopposed, I still have to put it on the record. And then I want to make sure that you all have an actual jury trial date for when you come back. All right. So if you'll just give me a moment because Ms. Ferguson will be here and we'll get your date. All right. You're welcome.
A great time because I'm actually leaving town and I won't be back till next week. So
Oh, my gosh. What time are you leaving and where are you going?
I'm gonna go up to Dallas for the rest of the week, but I'm leaving up to.
Oh, what are you going to Dallas for?
I'm actually refereeing a national water polo.
Oh, my gosh. Did you play water polo? Okay, water polo is one of the sports that I put sort of in the same realm as soccer.
Mhm.
Because it really takes a lot of stamina and you have to be in shape because you're constantly treading, then you're swimming back and forth. So how long have you been doing that?
Long time.
Oh, wow.
Yeah, I guess I started right when I got out of law school, so I've been practicing a few years now.
Oh,
I don't really want to go, but I kind of have to go.
so let me ask you, what school did you compete at?
Here in high school, I went to Jefferson, and then I played some club level ball in college right now.
So Jefferson had a water polo
Mhm.
team? Oh, I didn't know that. Do they still have a water polo team?
Not so much. So many districts getting smaller and smaller, so they're kind of consolidating, but I think they're really trying, so I'm hopeful.
Hey, you need to gear that up.
If I have time.
You know what? My mom always say we have to make time for the things that we enjoy.
Yeah,
So,
that's true. Just let me know when you're ready.
let me ask you, is your client here?
No, he lives in the valley.
All right. Can you have him zoom in very quickly or no? All right, let's see if he can get in. Otherwise, if you excuse his appearance on the record, if he can't get here and nobody objects, then I'll go forward.
Okay.
Just trying to use my investigative skills. Yeah.
And attorneys, we still have an Apple iPad that somebody left and nobody has claimed. So spread the word. We know it belongs to an attorney. Yes. All right, that would be great. If somebody left a Apple, we're trying to charge it. So maybe it'll pop up and see who it belongs to, but no such luck. Victoria, who is your client? All right, Juan Tehran, if you'll come forward. All right. So another jury trial was called.
Yes, sir.
So how long do you expect this trial to last?
3 days.
Oh, that sounds about right.
All right, Ms. Ferguson, on Juan Tehran. They need a reset date for jury trial. They say 3 days. Do you want to send this to the impact or no?
That one on September 5th.
Understood.
All right, so if you all will get the reset form, we're gonna have your jury trial on September 5th.
Thank you, Your Honor.
All right, you're welcome. Once you sign the reset, you're excused.
Thank you, Your Honor.
You're welcome.
Right there, and we're just gonna sign it.
Yes. Oh, if you could just have him zoom in, and let me give you the Zoom link. Here you are.
Kids. The twins are starting school.
Yeah.
My husband's twins. We have to get leave because the mom abandoned us. They're 5. They're gonna be 5.
Oh,
Oh,
that's
yeah.
awesome.
Yep, so really I have 3. Mine now. She's gone, let's put it that way. I just feel like people have, they're in therapy and stuff, but overcoming a father figure's absence is one thing, but a mother,
Mhm.
they do.
Yeah, they do.
And my mom is really good at it too. And she hasn't been it. Garcia? They do.
The key is they feel the love.
Oh, absolutely.
So that's great. Well, they say they have salmonella outbreak in 16 states.
Exactly. What is it?
I'm sure it's some sort of bacteria. Oh, and then of course it's in the raw cookie dough. I never understood the greatness of cookie dough. Thank you so much. All right, your client, what's your client's name, sir? Yes, he's zooming in. Jesse Inaho? All right, could I see the file on Inaho? And this one I'm done with. Thank you. All right. This is criminal, I'm sorry, this is family violence case. This is a request for a motion for continuance.
That's correct.
Okay. And it's the court's understanding that you all are not opposed.
That's right, Your Honor. The state is not objecting to the motion to continue.
All right, so we're going to go on the record. Thank you so much. Court is calling 2020 CR 10218, State of Texas versus Jesse Lee Inaho. Could I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense?
John Reitmeyer.
And are you Jesse Inaho? Excuse me, Mr. Inaho, are you able to hear us? Ah, we have a slight problem.
Are you on mute, Judge?
No, I think his audio is not connected. Okay, he's connecting to audio now. I always ask people, do you have Android or iPhone?
It makes a difference.
Oh, but you know what? I have an Android, so I'm always praying they will say iPhone. Because if they say Android, then I should know what's going on. All right, if you'll unmute. Are you Jesse Inaho?
Yes.
All right, your attorney has filed a motion for continuance. Do you have any objections to that motion?
No.
State, or do you have any objection to Mr. Inaho appearing by video?
No, Your Honor, the state has no objection.
All right. All right, according to your motion, you are going to be in Del Rio in federal court. Is
That's
that
correct.
correct? Do you, and what is the hearing about, or is it a trial there, or?
This is a docket call. The judges are requiring us to be at.
All right, so I understand the docket call, but are they going to immediately put you to trial the next day or no?
I'm not sure. I don't think it's the next day. I think it's a couple days later.
All right. So state, how long do you expect this trial to last?
2 to 3 days, Your Honor.
All right, so this is what we'll do. I'm going to excuse you for the 8th. And then I'm going to want you back here August 9th to let the court know, or you can call in to let the court know if you're actually going to be in trial in a couple of days.
Okay.
Because if you're going to be in trial the week of August 14th, then I'll give you a new court date.
Okay.
But if not, then what we'll do, we'll just do jury selection on the 9th.
Okay.
So Norma, on Jesse Lee Inaho, recall this for August 9th. And I'm going to make a notation that you may be in trial in Del Rio. Okay. So I'll grant your continuance for August 8th and move you to August 9th.
Okay.
All right, so Mr. Inaho,
Yes.
if your attorney is not in trial, and he will let you know, if he's not going to be in trial in a couple of days, you're going to need to appear in person in court. Do you understand?
Yes.
That's not good.
Start again.
So we have an issue? Oh,
Is there equipment?
we have a problem with the equipment. We'll see if we can correct that. All right, so we'll recall it for August 9th. Is there anything else?
No, ma'am.
Okay.
All right, thank you.
Thank you, Your Honor.
You are, yes.
Have a good day.
All right, drive safely.
That's right.
Boy, that was loud. Can you have someone from IT come down? All right, thank you. Everyone, the jury is coming in at 9:30. So,
Judge, I'm waiting on the attorney for Damien Huff, that should be Esmeralda Valdez, to have his defendant complete the court, the plea bargaining agreement.
All right, where is Eric Hernandez? All right, Norma, call these attorneys and tell them that the jury is going to be seated. If they're all here, they're being seated at 9:30. And anyone who is not here before that time, they're going to have to wait at the convenience of the court. I appreciate you letting me know. All right. Bashan, Jamisa says she cannot do an audiobook with our book because it's too intense.
So, yeah, so I read a good portion of it last night and
That's
I
fine.
myself reading like angry,
Yeah.
angrier by the minute.
Yeah.
Each page, I'm like, oh, my goodness.
Yeah.
I'm reading through my teeth.
Yeah. And Edith Brown, she said, I'm going to join you all for the next book.
It's intense, right?
You ready to?
I'm ready. Yes, same here.
He speaks a little English, but Spanish is a better language. He may need an interpreter. Yeah, I mean, he speaks some English, Spanish.
I need you to do some out the first respirator. Okay.
Donna, they said they're bringing back food truck days. So the one that's coming up is July 28th. Yes. I don't know why they got rid of that. There was one that was the Nor'easter, and they would always have the lobster, the shrimp, and I can eat anything seafood.
I'm sorry, I'm sorry.
No, you're very late. Yes.
I'm here as reported. No one was calling.
All right. Welcome.
Jose Diaz.
All right, thank you so much.
And Deputy Laura, do you know if all the jurors are here?
Let you know.
All right, thank you. Jose Diaz. All right, this is scheduled for jury trial. Yesterday was plea deadline date. Were you rejecting the plea?
I was just talking about the new one that was made yesterday, Judge, because he was moved. I didn't get a chance to go over it with him.
All right, you can go over with them.
Oh, yeah. It's never mind, Daniel, it's right here.
And Norma, if the jury is all here, we're starting exactly at 9:30. All of these other people will just have to wait.
Just waiting on. Or him.
Yeah. Just, I'm just waiting on you. They're only missing two.
All right.
It's like an anxiety thing, and it's about trial. And the fun part is judge was the presiding lawyer.
No way.
Yes, she was.
Oh my God. You're just judge.
Oh, what?
I was having like an anxiety dream, like
Mhm.
about trial last night, and it was like Fort Dyer. And it was really weird, because like Doug was there, but he wasn't really trying the case, but he was distracting me. So I didn't really pay attention. You were the presiding judge. Kristen Mulliner was the prosecutor. I know it was some type of kid case.
Yeah.
And Carl Basil was like lead, and because Doug distracted me, I didn't pay attention what happened. And just Carl stormed out like angry about something. He goes, "That's it, it's over with." And I'm like, what? And like he hadn't really done the voir dire yet. And I'm like, "Judge, can I please like finish the voir dire? Like she's the break. Like you can let everybody have a bathroom break." And then I was running around this building, which I think was really like a federal courthouse, but it's not one I'd ever been in. It was just weird. It's one of those weird kind of.
Louis, are you ready?
Judge, we don't have an agreement. I know you're getting ready to go back to trial. Can we run the judge talk about
Sure.
what was over there?
Yes,
Thank you, Judge.
you're welcome. And who's here on Robert Garcia? Robert Garcia?
It's Karen Corby hearing. I'm sorry, Judge.
Yes.
Chris Simpkins on one of the case, but he had to go somewhere, so I told him I'd announce for him. We're
All
not
right.
ready, Judge.
Where's Robert?
Robert is
Garcia.
right here in the box.
All right, Mr. Garcia, come down. So where are we on this case? Do you have all your discovery?
Believe so, Judge.
All right. So has an offer been tendered?
Yes, Your Honor.
And how old are you?
28, Your Honor.
All right, Ms. Ferguson, on Robert Garcia. On Robert Garcia, needed 30-day reset for a plea deadline date. All right, your plea deadline date is going to be August 29th. On that date, you need to let the court know whether or not you're accepting the state's offer. If you choose not to, then what will end up happening is you will be scheduled for trial. The court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you. Is there anything else?
No, ma'am, excuse.
Yes. All right, who's here on Chris Macias?
We have a fresh agreement on Jose Diaz, Judge. so
Okay.
They're gonna work on the paperwork.
All right, thank you. They have an agreement on Jose Diaz. Who's here on Jorge Macias Castro?
I am, Your Honor.
All right.
Aquí en medio.
All right.
I don't think it is.
In other words, we'll see.
All right. And then let them know that this keeps flickering. Hi.
Hey.
All right, so we have an interpreter. We're not on the record. The last time we were here, there was a motion for continuance, an oral motion for continuance was granted.
That's correct, Your Honor.
So this is, I'm going to give you all a jury trial date and a plea deadline date. The jury trial date and plea deadline date will be the same date. This is an old case.
Correct, Your Honor.
How long are you all expecting this trial to last?
3 to 4 days, Donna.
I suspect that's correct. Maybe one other day for defense.
All right. Ms. Ferguson, I need a reset jury trial date on Jorge Macias Castro. And where are we on the immigration attorney? Have they talked to him?
They have, Your Honor.
August 3rd. No, I'm sorry, October 3rd.
All right, October 3rd will be your jury trial date and your plea deadline date. If you decide not to accept an offer on that date, the court will not consider any offers after that date without good cause. Otherwise, you have to plea open to the court.
You did say the 3rd, correct?
Yes, October 3rd.
Thank you, Your Honor. May we be excused?
Yes. Well, before you excuse me, sir.
Espera, porque-
Do you have any questions?
No.
All right, thank you.
Now maybe we'll be.
Yes, you may now be excused. All right, can I see the parties on Damien Huff? Where's Mr. Huff?
Your Honor, that's why I'm approaching the court. He is not present. I have called him and sent him a text. He was here yesterday. We were working on the plea paperwork. My honest opinion, he may have had some reservations about taking the plea last night. I have not heard from him if he chose.
All right,
not
you
to
may
take
want to
it.
call the bondsman because he's supposed to be here today.
I
So
understand.
I'll give you till 1:30.
Thank you, Judge.
You're welcome. That's done.
Thank you.
And Deputy Laura, can you see if the jurors are here? I'm sorry, who? No.
Thank you.
I don't even have Villanueva on the docket today. Okay. All right, thank you. All right, thank you. All right, state on Raul Reyes. Do you all want to have your hearing on your outcry?
We can't, Your Honor, yes.
All right, let me see where the defense is and her client. As soon as they come in, we'll take that up.
Yo les aviso a tus padres cuando va a ser la nueva fecha, ¿ok?
Yes. All right, thank you. I need this file pulled. Mhm. And state on this jury trial, if the defendant were to be found guilty, did you all elect to go to the judge or jury for punishment? All right, thank you. All right, did he already leave? The tech person?
No, he's working.
All right, because this screen is down. Okay, all right, thank you. Okay. And defense on Mr. Reyes. Since we're still waiting for jurors to arrive, we'll do a hearing on the outcry if you all are ready to do that. All right, if you all could, and then we'll take that up. All right, are you all ready?
We're ready to approach and address a pretrial matter down there.
All right, could I see the file on Reyes, please? All right, we're going to go on the record. Excuse me. If you, hi, if you all could move down there just a little bit, thank you. All right, court is calling 2022 CR 4920, State of Texas versus Raul Reyes. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense
Megan Enriquez for Raul Reyes.
and,
It's from Mr. Reyes.
and are you Raul Reyes?
Yes, ma'am.
All right, my understanding there was a matter that the defense wanted to take up with the court.
Yes, Your Honor. Two separate matters. I'll start with in our preparation last night. In the prosecution guide, there's reference that CPS was notified in this case, and it references CPS case number 751999752. I double checked e-discovery. We do not have CPS records. I've mentioned this to the state. They're unclear as to whether or not they've ever been requested or ever been in their possession. Furthermore, a couple of other things that were discovered was that the child's mother had an injury to child case herself
Mhm.
from just 3 months prior to her offense date was 3 months prior to our client's offense date. She had a pending injury to child case from out of the 186. She's now on felony deferred for a drug case that her injury to child case got taken into consideration as part of her plea. Not sure what her conditions are, if that includes things like parenting classes, things like that. If it includes staying away from my client for some reason, and so that could be kind of impeachment evidence, motive to lie, motive to cooperate with the state.
I don't see how her deferred adjudication is relevant. However, that's easy to rectify. State.
Yes, sir.
You can have probation, pull up her conditions of probation from the 186.
Yes, sir.
The CPS records, someone needs to walk next door to the building with a green rooftop, tap on the shoulder of one of the prosecutors, either in the 306. I think the other courtroom is 307 over there. It's on second floor. It is Judge Burley or either, I can't remember the name of the other male judge because they've changed. Tap on the shoulder of the prosecutor over there and ask them to pull that CPS case. And they will be able to pull it and hand it right to you.
Yes, because I would like to know, Your Honor, also if there's if there was a safety plan in place at the time for her own case,
Mhm.
that he wasn't supposed to be at the house, or she wasn't supposed to have a convicted felon in her house, which he is. Because that's impeachment evidence. She says that they were not in a dating relationship, which we allege that they were, that he lived there. And now I see the motive why she would potentially say, oh no, we weren't dating. He's just some guy I knew from the neighborhood.
All right, so I just solved those issues. Somebody's going to go next door, tap on the shoulder of the prosecutor over there and ask them to pull that safety plan. What's the next issue?
Third thing, I was just this morning handed a disc with 5 jail calls. They're approximately 17 minutes long each. So a little bit over an hour of jail calls.
So when were these jail calls alleged to have been made?
Those jail calls are from the 16th and 17th of this month, Judge. There was some potential statements that were made that are alleged to have been made by either the defendant's mother or the defendant's girlfriend or mother of his children about contacting the complaining witness's mother in this case. Those came to our attention yesterday. We pulled them and we handed them to counsel as soon as we received them this morning.
All right, so the jail calls that the defendant is alleged to have made was on the 17th.
Correct.
And the 16th.
17th and the 16th, and you became aware of them when?
Yes, last post jury selection, yes.
All right, how did you become aware of them?
From the, I believe it was told to us by the complaining witness's mother when we contacted her to be here at this time. She let our advocate know, who then let us know. And we did let defense counsel know as soon as we became aware of it yesterday that we were going to be pulling those jail calls to see about any potential.
All right, and so when is this witness, if they're expected to testify, when are they expected to testify?
This morning.
And well, defense, if it's something that they've just received, I thought this was maybe a situation where he made jail calls, they had pulled all these jail calls and they had not been listening to them. But if it appears to me, and if I'm wrong, correct me, it appears to me that some witness made them aware that there were some jail calls where your client was calling them or calling someone else. I don't know what the content of them, what the content of the calls are, but it appears they were just made aware of it. So therefore they pulled them. So I'll give you a chance to listen to those.
And Your Honor, I would argue that they have had access to them for the full 10 days that they've been in their possession, because their investigator could have pulled them on July 16th, on July 17th. So I would argue that they have been in the state's possession for 10 days and 9 days on each call. And we were entitled to, I believe it's 10 days to listen to them.
I'll let you all listen to them. Next, what is the next issue?
Those are the three issues.
All right, so somebody needs to run next door now, tap on the shoulder to the prosecutor and see about her safety plan. Someone needs to ask a probation officer to pull the mother's conditions of probation.
Yes, sir. And I was just notified that my partner, Mr. Banks, was able to listen to those jail calls. And the state will not be using those jail calls at this point. So
State
will
is
not
not,
be introducing those. Jail
all right,
calls.
they're not going to introduce them, but you'll still have a chance to listen to them. And I will tell you this, if you listen to those jail calls and you wish to recall the state's witness after they testified, the court will still allow you to cross-examine them as opposed to using it as direct examination.
Your Honor, the issue that I foresee is my client's own statement, like a statement that they could use against him.
They're saying they're not going to use it.
Okay, but they say that now, but what if their strategy changes mid-trial and I haven't had time to listen to
Oh,
it?
we're going to cross that bridge when we come to it. But for now, they say they're not using it, so it will not be coming in. However, you will still have the disc to listen to in case you would like to use it.
Okay.
And therefore, if you would like to use it and you want to call back whatever state's witness was, I will allow you to cross-examine them, even though you will be calling them as your witness, if you choose to do that.
Okay.
All right, so pull the probation for your witness so that the defense will have our conditions of probation. And nobody's moving. Somebody go tap on the shoulder of the prosecutors next door for their CPS records. And they have the cause number. So if you would like to accompany them over there, they will be able to look it up quick, fast, in a hurry and tell you what the safety plan was.
Your Honor, our investigator already worked.
Okay, awesome. Do they have the case number that defense counsel has?
Yeah, sure. But we have sent it to our investigator. We do have the reference.
Well, and Your Honor, just to clarify, I would like the CPS records for her own injury to child case, plus the ones regarding this case number that's referenced in my client's case. Or CPS cases.
Okay. All right. They're gonna pull it quick, fast, in a hurry.
Thank you, Your Honor.
Do you have?
Mm-hmm. Thank you.
Thank you.
Who is she here for?
Might be. Right here, next to the other.
Who is his client?
Yeah,
Judge, would you like to proceed with the outcry statement?
Just give me a moment.
Okay.
Sure. Arturo Villanueva. All right. Is your client a citizen? Mr. Villanueva, are you a citizen?
No.
All right. Are you retained counsel?
Yes, Your Honor.
Are you going to make sure he sees an immigration attorney?
Yes, sir.
I don't need it.
Oh, you don't need it?
Oh, you don't need an interpreter?
No.
Oh, well, thank you very much.
What's that?
All right, where are we on discovery?
So Judge, we didn't have a file out with us. We couldn't find it this morning. So that's the first thing that we're going to do after this is make sure that we can locate the file. As far as I'm aware, defense hasn't raised any discovery issues.
Oops, sorry. The only issue is I don't have it, but so I don't know the facts of the case. And my understanding is it was an at-large filing.
Mhm.
So
All right, Ms. Ferguson, give me a 45-day reset for discovery, please.
And Judge, I'll give an offer in between now and then.
All right, thank you. All right. You'll be back on September 21st for discovery, and state will make an offer before then. Once you sign the reset form, you're excused. You'll need to speak to an immigration attorney before then as well. Do you understand?
Yes.
All right, thank you. Is there anything else?
No, Your Honor.
All right, thank you. You can leave after you sign the reset form. Esmeralda Valdez, thank you so much for coming.
This is for the, are you okay? Forgot to bring it. Thank you so much. Maybe excuse me.
Yes.
Thank you.
Just leaves it for us, so I'm gonna head upstairs.
All right.
But if you guys need anything, let me know.
All right, thank you.
This lady's writing everything down.
Court is calling. Excuse me, can I have a file stamp on that? Court is calling 2021 CR 8727, State of Texas versus Esmeralda Valdez. Can I have parties announced for the record for the state
Hank Wilkins for the state. Your Honor.
defense?
John Coons from Ms. Valdez, and I'm standing in for Ms. Enriquez.
All right, any objection to this attorney standing in for Ms. Enriquez? All right, you're gonna need to speak up.
No.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, so here's the thing. You're gonna have to speak up. If you cannot speak up where I can hear you and the court reporter can hear you, then I will send you back. And then once you're able to speak up, we will bring you back. Do you understand?
Yes.
Showing you what's entitled true bill of indictment. Did you review this with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Are y'all proceeding on both counts or just count one? Count one only, is that correct? Or count two? Count two?
I believe we were doing both, Judge, because they're different, different substances. I looked at the waiver and steps and it had both counts in it, Judge. What is the thing on it?
Oh, it just says punishment is be assessed at 2 years. It doesn't say if
I
you're.
think it's both counts. I believe it's both counts because count one is the heroin and count two is in that.
Okay. Thank you. All right, Ms. Valdez, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand in count one, you're charged with possession of a controlled substance penalty group 1 gram to 4 grams. And in count two, you're charged with the offense of possession of a controlled substance penalty group 1 gram to 4 grams. Both of those counts are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, we do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? And did you sign it?
Yes.
According to the plea, punishment is be assessed at 2 years in the prison on count one and count two. There's a $500 fine. There's to be restitution of $57 to SAPD for drug testing. All right, off the record. So guys, on this one, you all didn't put in here that it's for probation. Is it recommended probation
It's
or
a
not?
recommendation.
All right, if you all could write in there that you all are recommending probation, if both of you will sign it, and also if you put in there that you're pleading to counts 1 and count 2.
I did.
Oh, no problem. It happens.
What we talked about.
Thank you. All right, according to the plea bargain agreement, you're to plead, well, the state is proceeding on count 1 and count 2. They're asking that your punishment be assessed at 2 years in the prison. There's a $500 fine. There's restitution of $57 to SAPD for drug testing, regular UA, sober support meetings, and the state recommends probation. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
I have not.
Outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
Then to count 1, how do you plead?
No contest.
And count 2, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Your Honor, I submit State's Exhibit 1 in the attachments.
We've reviewed them and have no objections, Your Honor.
Showing you was entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty as charged in count 1 and count 2. Are we proceeding with sentencing?
We would request that today. Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would request that you follow the plea bargain. This is slightly unusual in that this is not a deferred offer, but my client had conferred with Ms. Enriquez yesterday and decided that she didn't want to apply for deferred. So we would request that you give her the 2 years probated for 3 and run those counts concurrently.
All right. If you're released today, where would you be living? And with who, I should say?
My mother.
Does your mother want you staying with her?
Yes.
Did you ask her, or are you just assuming because she's your mother, she wants you to stay with her?
No, I asked.
All right. When's the last time you asked?
I spoke to her before I came in to jail.
All right. What's your drug of choice and how often are you using? Huh?
Yeah,
Heroin? How often are you using heroin? I'm sorry?
occasionally.
No, you're doing more than occasionally if you're going into places and taking people's things. How often are you using heroin? Here's the thing. I'm trying to consider not, one, whether I'm going to follow this plea bargain agreement. Two, I'm trying to consider what would be best for you. Now, it appears that you agreed to your underlying sentence being 2 years. If you just want to go for prison for 2 years, I will send you today to prison for 2 years. But otherwise, you need to be honest with me, because if you're not, you know what I'm going to do? I'm going to send you out. I'm going to follow this plea bargain agreement, send you out to the free world and have you call the UA hotline. And at some point in time, you're going to get caught for using heroin. And then you know what's going to end up happening? They're going to file a motion to revoke and you're going to be right back at jail. And you're going to come back to me. And then you're going to say, oh no, I need help. I use heroin. So you need to be honest with me. How often are you using heroin? And it's not occasionally. I know that much. Why was that so hard to tell me? I'm sorry?
Are you embarrassed?
All right. Well, here's the thing. We are all on a journey, hopefully, of improving our lives. Where we are now is hopefully not where we will end in our growth. So hopefully today, maybe today will be the worst day that you can have. And maybe from here on out, you'll make changes to improve yourself and you won't be back. You won't be using heroin again. You understand?
Yes.
How many children do you have?
None.
How far did you go in school?
10.
Why did you drop out?
Attendance.
I'm sorry, what?
Attendance. My mom took me out.
Why would your mom take you out of school?
Because she had a problem. I was not going, skipping.
Were you struggling with drugs already at that point?
No.
All right. I don't think her mother is the person for her to be living with this. If you have a mother who's going to take somebody out of school at 10th grade. Have you ever had employment?
Yes.
Doing what?
Worked in 7-Eleven.
How old are you?
27.
All right. This is what the court is going to do. I'm sorry, before I do that, any other questions, Mr. Kuntz?
No, Your Honor.
All right. All right, I'm going to sentence you to 2 years in the prison, suspended and probated for 4 years. There's going to be a TAP evaluation while in custody. Follow all TAP recommendations.
Do we know how long it's taking for the TAC evaluations?
How long?
1 to 2 weeks.
Okay, right.
All right, $57 restitution to SAPD. There's going to be 90 sober meetings in 90 days. And I know you all were recommending sober support meetings 2 times a week. That's your agreement. But I think she needs more than that. So I have not followed your agreement with regards to the sober meetings. Is there going to be an objection?
No, Judge, and just for the record, I've explained to my client about with regard to the restitution and the fine and the court costs and things, that the most important thing for you is to make sure she shows up where she's supposed to show up, when she's supposed to show up. Even if she's running low on money and can't necessarily afford the probationary fees or anything like that, as long as she shows up and tries to stay in compliance with everything else, that she should be okay with you.
Yes. We're going to do the UA hotline until further notice. $500 fine will be probated, proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. Those hours will be waived if you obtain your GED or if you obtain some sort of trade certificate or something that can make yourself better in place to get employment. You understand?
Yes.
There's to be regular reporting by Zoom or in person. I'm going to want field visits 1 time per month until further notice. Probation, is there anything else she needs? Yes. So you're going to either have to obtain your GED or complete some sort of trade school. But once you do that, your community service hours will be waived. You understand?
Yes,
But regardless, you have to complete it.
yes.
Is there anything else you need from the court to be successful?
No.
All right. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes.
All right, can we go off the record? All right, what are the tattoos about?
My miscarriage,
No, I'm sorry.
my ex-relationship is passing.
All right, and on the other arm?
This is, a clean card.
All right, is there any gang affiliation involved with you?
No,
Any gang affiliation involved with in your past relationships
no,
with the people you were dating?
no.
All right, so probation, if you can make sure you look into that. All right. Is there anything else you need from the court?
No.
All right, in this court, communication is key to be successful on probation. If there's an issue or something that's going wrong in your life and you need some help with it, let probation know. If you feel as though they're not addressing the issue, you can always come to court and let me know and we'll see what's going on.
Okay.
All right, good luck to you.
Thank you, Kurt.
You're welcome. All right, what's the update on next door? Oh, no problem.
We're checking with our investigator right now on that, Judge. We were able to get the probation conditions already in the weekend.
All right. And so is your investigator just walking next door to grab the papers from the prosecutor? Or are they doing something else?
That is what we're.
All right. Tell him all he has to do is go right next door to 306, 307. This, I'm going on the government site.
We will be calling.
All right, thank you. All right, are you all ready to do the outcry?
State's ready. Yes, the state's ready.
Defense, are you ready to proceed on this outcry?
Almost, Your Honor.
Okay.
Judge, I believe we've done all the CTD cases.
Yes.
Maybe we'd be excused.
Oh, of course. Have a great day.
Thanks, you too. See you later.
Too.
Yeah.
Yes.
Yeah, because he said that these guys. I already have all the pictures.
For a flea or something? Oh.
Yeah.
Yes. Judge, can I run to the 227th for a minute?
Yes.
Okay.
All right, let's go.
How we would get that.
American Morgan's came back and asked me if we can do that pretty orange top. Bringing Mercy.
Is he here?
He is here, and he had one portion of his bargaining paperwork to sign. And then I swear he was like,
All right. Yes, just go ahead and swear him in.
oh, this is on hers. So I just gave my son to they go to walk or something. Well, there's.
Tell them 10:45. Mhm.
He had the rest. And they, you know, honestly, the public is like, school. The only reason he goes to be involved is the and then for she did see the
Vashon, this paperwork you sent me, Janelle Trejo, 2022 CR 6575. Is she still on probation on 6574? Two CR 6574. I think she's still on probation for that case. Is that correct?
Yes, Sean, our show will be on probation on that 7/4 until 9/19/2024.
All right, thank you. So this one, the possession less than a gram case, she's completed everything.
It is so.
All right, thank you. Hi. Oh, no problem. Oh my gosh. Thank you so much. You're so awesome. It was great having you here. But I didn't know when I was whenever she's ready for the sizes. This is so awesome. Thank you so much. And if you ever need anything, you're always welcome here. Yes, thank you. All right.
Just bring me.
Your Honor, that Sister Huff did show up.
All right, thank you. Oh, this is such a sweet card. Thank you so much. So we have a beautiful card from the intern. Yay. All right, and did you all do a discovery acknowledgement on Reyes? Because I don't have one.
I can get one.
All right, thank you.
There's any trying to get outside. I turned in my paperwork.
Oh, no, I'm just waiting for the paperwork to come to me and then we'll take it up.
I think you have one ahead of me, so maybe she's to use the facilities and I'll put that back.
Okay.
Thanks.
And what?
All right, court is calling 2023 CR 3681, State of Texas versus Damien Huff. Could I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense,
Kirk Hernandez for the defense.
and are you Mr. Huff? Counsel, have you received all the discovery and did you review it with your client? Counsel, have you
Yes.
received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is this an application for regular or deferred?
Deferred, Your Honor.
All right. Mr. Huff, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your
Showing you what's entitled true bill of an indictment. Did you review that with your attorney? Did you understand it?
Yes, Your
Counsel, do you waive the reading of the indictment?
We waive, Your
State, are you proceeding on the indictment as presented?
Your Honor, the state would be proceeding on paragraph A and waiving paragraph.
Any objection?
None whatsoever.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Your Honor.
Did you understand you're being charged with the offense of burglary of a habitation with intent to commit assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights in entering a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty and sentence you up to 20 years in prison?
Yes.
Did counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, that's to both.
Mr. Huff, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? All right, you're gonna have to start speaking up. Your voice is trailing off.
Sorry. Yes. Yes, Your Honor.
According to the plea, state recommends deferred adjudication. They're taking consideration JN 2108501. And there's to be no contact with Jonathan Escobar and Ashley Barron, BARRON. Did you understand that to be the plea?
Yes, Your Honor. Yes,
Defense,
Your
is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
Is there an affirmative finding in this case or no?
It's not in the paperwork.
All right, Mr. Huff, if the court reads the stipulations in this case and I determine that this should be an affirmative finding of family violence, I will find an affirmative finding of family violence. Do you understand?
Yes.
And let me tell you the consequences of that. If I find that there's an affirmative finding of family violence, two of the consequences is you will not be allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
The other consequences would be that you're not allowed to be designated as primary custodial parent. Do you understand?
Yes.
All right, then did you understand?
In regards to the no contact order, Mr. Huff did inform me that the complainant reached out to him last night by text. He did not respond, but she is maintained, I don't know for what reason.
Okay.
But just want the court to be aware that she is reaching out to him, but I've advised him not to contact her or to respond.
All right, did you understand that to be the entirety of your plea bargaining agreement?
Yes. Yes,
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph, did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years. There be a TAP evaluation following those recommendations and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence
No objection side.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Mr. Huff, you seem sort of hesitant. Is this an agreement that you wish to go with? Are you entering this plea freely and voluntarily? Do you want to enter this plea?
Yes, Your Honor.
All right, you're sure?
Yeah.
And you wish to proceed with this case and solve this case in a plea agreement?
Yes.
Okay. All right, are you,
If it satisfies the court, I've asked Mr. Huff that several times and we've discussed everything. To be sure that this is what he wants to do, because I too had the same concerns about his hesitance, but I do believe that this is his desire.
all right, are you employed?
Yes.
What do you do?
I'm a line cook. All right, cook.
Where do you cook at?
La Fonda on Main Street.
All right, do you have any children?
No. No.
All right. Do you live with anyone else?
No, just currently staying with my mother or my sister.
Okay, all right. And if you're drug tested today, what are the results going to be?
Alcohol.
All right, you can't drink alcohol while you're on probation. It's not allowed, you understand? And alcohol is what got you here today.
It is.
So you're going to have to stop drinking.
That's. Yes,
All right, the court is going to send, everyone needs to whisper. Court is going to sentence you to 4 years deferred adjudication, taking consideration JN number 210851. There's to be no contact with Jonathan Escobar and Ashley Barron. There's to be anger management classes. We're going to do supportive outpatient treatment with him. And we'll do the 90 meetings in 90 days. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular UAs, make sure there's testing for alcohol. Regular reporting by Zoom or in person. Field visit one time for 1 month, and if everything is okay, that can be discontinued. And that probation, is there anything else he needs?
No, Your Honor. In order for him to do the support of
All right, we'll do a TAP evaluation. And of course, regardless of what TAP says, we're going to start with supportive outpatient treatment. So if it asks for inpatient treatment, that's where we'll begin. Is there anything else you need from the court to be successful?
I just hope the only thing is, I can curb my alcoholism. I think I'll be on my way to being a better person.
Okay, all right, you're going to have to stay vigilant. And it's probably best for you. I know your mom loves you. I know your sister loves you. Tell them don't have you around any alcohol, okay? And Vashawn, can you add that he is not to work at any location where alcohol is the main source of revenue? So that means that you can't work at bars, ice houses, or anything of that nature. Where you're currently working, that's fine. Or if you work at a restaurant, that's fine. You understand?
Yes, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do.
All right, we can go off the record. I understand that when people are in relationships and they go bad, and maybe it's a bad breakup, and maybe you think that person was dishonest with you, and then you show up unexpected like you did here, and you see another guy on the scene, and you think in the back of your mind, well, maybe that person was cheating on me all along. Here's the thing. How old are you?
28.
And how long have you been in a relationship with this person?
5, 6 years.
So you've been on the planet longer than you've been in a relationship with that person. When you feel as though someone may be cheating on you, or if you feel that someone is not treating you right, you have two choices. First choice, I'm going to accept it. I'm going to let them treat me this way. Second choice, I'm done. Cut them loose. Call it a day. And if you're in a healthy place in your life, you know what your choice should always be? I deserve better than this. I'm done. Goodbye. Good luck to you. Now, your attorney is telling me that this person is contacting you. So maybe this person has decided, I want you back. You need to remember that that is not a healthy relationship for you. And you also need to remember that I just told you, you can't have contact with that person. You understand? So if you need to change your number, then change your number.
Sure.
All right. Good luck to you.
Okay.
Oh, there you go. All right, who's the other plea that's ready? Any other plea that's ready?
I think we just need one signature from the state, and my client is sworn in.
All right, bring him up, and then we'll do the outcry. State, what's the status on the CPS records?
We did tender them over to council.
All right, thank you. I'm sorry? Yes, I can hear you.
I just want to make sure he speaks facts.
Okay, awesome. I don't know why people shout. And then when they come in court, you can barely hear them. Everybody's whispering.
Because it's a solemn setting. I don't know.
I like that.
They think they're in church or something.
Yes. Which case are you all pleading on?
Both, Your Honor, and there's motions on both.
Court is calling 2023 CR 0685 and 2023 CR 0528. State of Texas versus Jose Angel Diaz. Can I have parties announced for the record for the state? Defense?
Carl Alexander for Mr. Diaz.
And are you Mr. Diaz?
Yes, ma'am.
Counsel, in each cause number, have you received all the discovery and did you review it with your client?
I've received everything to the best of my knowledge, Judge. We have discussed it.
Court will find in each cause number that the state is in compliance with discovery. Are there any applications on these cases? All right, probation, there's no application. And each cause number is showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? State in cause number 2023 CR 0685, are you proceeding on the indictment as presented?
No, Your Honor, the state would make a motion to proceed only on count 2. Furthermore, reduce that count to ABI family class A misdemeanor. And also waive and abandon any habitual enhancements in that case.
Any objection? And stating cause number 2023 CR 0528, are you proceeding on that indictment as presented?
No, Your Honor, in that case, the state will be proceeding on a reduction to the ABI family misdemeanor. And also waiving any habitual enhancements.
Any objection?
No, Your Honor.
All right, in each cause number, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each cause number, the state has proceeded on the lesser included offense of assault, bodily injury, family or household? That's a class A misdemeanor. The range of punishment is it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Okay.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor. To that issue, Mr. Diaz was evaluated for competency and there was a judicial determination that he is competent to stand trial.
Mr. Diaz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Did anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, I'm showing you what's entitled plea bargain page. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
According to the plea in each cause number, the state is proceeding on the lesser included offense of assault, bodily injury, family or household. Punishment is to be assessed at 1 year in the Bexar County Jail. There are no applications. The cause numbers will run concurrently. There's an affirmative finding of family violence. Of course, you'll receive credit for any time served. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state?
Yes, sir.
In each paragraph, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No evidentiary.
Then to the offense as charged in each, the lesser included offense is charged in each case. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State for State's Exhibit 1 and its attachments in both cases.
We've reviewed both, Your Honor. We have no objections.
In each cause number, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am, yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty in each cause number, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
No, Your Honor, just ask her. She followed the plea bargain.
In each cause number, the court will find you guilty, sentence you to 1 year in the Bexar County Jail. Each cause number will run concurrently. And each cause number, there is an affirmative finding of family violence. And each cause number, I give you credit for in any time served. And in each cause number, there's to be no contact with Briselda, Briselda, Villarreal. Is there anything else from either side with regards to sentencing?
The state.
Nothing from the defense.
And each cause number, and show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it? According, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because there's an affirmative finding of family violence in each cause number, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I read in the police report that the complainant called the police to come out, and then the complainant says, no, I don't want to continue with prosecution. Here's the thing. If you love her, do you love her?
Yes, enough to just say, you know what?
Oh, no. Obviously, you don't love her, right? If you do, it's selfish. And the reason why I say that is because you do not put your hands on someone in anger if you claim to love them. So I've told you no contact with her. That means that relationship is over. And if she still wants to have a relationship with you, you need to say no. And you need to work on your anger issues. Get an orchid. When you get an orchid from one of the grocery stores, they already have blooms on them and they're beautiful. Keep that orchid. When all those blooms fall off, if you can get that orchid to bloom, you may be ready for a relationship. I say that because orchids take patience, and no matter what instructions or directions they give you on there, they do not work. You understand? Good luck to you. Thank you. God bless you too. All right, we're going to do the
It's the first chair prosecutor calling Megan.
okay.
Thank you. I'll set it up.
And then after that, can you put your outcry witness on the stand, please?
Can't be excused, Judge.
Yes, you may be excused. Oh, time out for you. Oh, thank you. And just head up, Judge. Oh, no, I understand. Can you mute us, please? what are we doing with this trial?
Maybe.
All right, can you start video, please? All right, you all have, everyone, 5 minutes, because the jury has been waiting since 9:30, so 5 minutes.
Yes, Your Honor.
This is all, this is all the process.
Yeah.
I'm John.
No.
Billy.
Hello, I'm Ruby.
No.
Ruby's a wonderful name. Our assistant is Ruby. My muzzle assistant. Great name. Oh, I'm sorry. Yes.
Ruby. It's nice.
Thank you. All right, so we're going to go forward with the outcry.
Okay. Your Honor, can we
I
have-
can do that, Your Honor.
No.
I can do that. You can go ahead.
All right, so my understanding, defense, they're talking things, but we're going to have this outcry hearing.
Okay.
All right, we're going to go on the record. 2022 CR 4920, State of Texas versus Raul Reyes. Could I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense?
Megan Enriquez and John Kuntz for Raul Reyes.
And are you Mr. Reyes?
Yes, Your Honor.
And it's the court's understanding that defense, you have received the state's witnesses probation conditions. Is that correct?
Your Honor, we received a list of the probation conditions. There are 2 instances that say see list attached for certain conditions of the specific or conditions within that certain condition. We don't have those attachments.
All right, we'll get those for you in a few minutes.
We've been provided 2 new sets of CPS records. One is 31 pages, one is 37 pages. We're not fully done going through them. Mr. Kuntz is going through one of them. I'm on page 15 of another one.
Okay.
And apparently there's a 3rd set that we still don't have. That they're still working.
All right, because could somebody explain to the court, why is it the day of trial, a jury selected, and all of a sudden there are CPS records that are discovered? When, I will tell you, when I was practicing, and I know people say, Stephanie, stop saying when you were practicing, but when I was practicing, here's a hint, if there's a sexual assault of a child, guess what? There's probably going to be CPS records if that's the boyfriend, husband, or somebody living in the home. If there's a case involving a child abuse, somebody hits a child, somebody spanks a child, whatever, if there's an injury to a child, there's going to be a CPS record. Either it's going to be CPS goes out and they just say, everything's great. The danger has been removed, which means the person who's alleged to have committed the offense is in custody. Why are we always here at the last minute with CPS records? When everybody should know that there are CPS records in a family violence case. And I take time and discovery compliance. We had a discovery compliance on this case, October 20th, 2022.
Just for the record, Your Honor, I did not represent him at that time.
Yeah.
I came on just a few months ago.
Right. So I guess now, in every case, I'm going to take it upon myself to say, is there CPS records? And I'm going to have to send everybody out to do some research to find if there are CPS records, because we had a jury here that said we're going to start at 9:30 and it's almost 11 and we haven't started because we don't have CPS records. CPS records have just been turned over. We don't have somebody's on probation and we don't have their conditions of probation, which I think Bashan, and this is not even her case, and the person is not even on probation with her, but it's all hands on deck and she's pulling records that should have already been done before we start trial. So what we're going to do is, my understanding off the record, everybody said, oh, there may be a different offer that was never made before. So I gave everybody 5 minutes. So if there's going to be an offer that has never been made before, then that needs to be told to the court now. Because otherwise what's going to happen is we are doing this outcry. The jury is going to be allowed to get several witnesses in because they've been here since 9:30. And everybody is getting 2 minutes for opening statements. 2.
Your Honor,
Yes.
if I may, for the probation records, I've provided the conditions and any amended conditions that were in your file. As far as the original conditions where it states the attachments are simply the referrals for the parenting class, all of the vendors that we have. There's no attachment as far as what the terms of what the classes entail for the particular vendors or anything like that. It's just the list of the vendors.
Okay. All right. Thank you. So defense? Well, John, you're aware of what probation has just stated.
Yes.
So there is no attachments of other conditions.
It's the reduced charge. The injury to job.
Yes. Judge, we're gonna enter a plea bargain. It's gonna be an 18-month state jail sentence.
All right. I will consider that once I see the police report so I can know exactly what this case is about.
Okay.
Again, the
So
paper.
they're gonna work on the paperwork right
All right.
now.
Oh,
You want to sit there?
would you like to venture out?
Yes, ma'am.
All right.
Thank you.
But please be around because I don't know if I'm going to accept this plea or not.
Yes, ma'am.
Thank you. And we're off the record. John, this is where I remember Judge, I'm not going to mention the judge's name, but there was a case and I was just sitting in the gallery, not a part of the case or anything. The defense attorney was, Stephanie, will you just sit and, take notes or something for me? I'm like, okay. I wasn't even sitting at the table. I'm just in the gallery taking notes. And the judge granted a motion in limine on something. And I know that sometimes when somebody says over and over, remember the motion in limine, remembering the motion in limine, it's just in your head and all of a sudden you're violating the motion in limine, right? So this attorney, after they had said it over and over and over again, and Rita Spiegel was the prosecutor, and they took, a 2-minute break, I told the attorney, I said, I know everybody's been saying, remember the motion in limine, remember the motion in limine. I said, but you should probably write that down because I know what happens when somebody keeps saying something and over. It's like the movie, The Children of the Dam, when they say, don't think about the brick wall and everybody's crashing in the brick wall. So you should watch Children of the Dam. It's from I think it was a 1960 movie. So anyway, I write him a note. He's looking at the note. He's like, again, I'm just in the gallery. I'm not even at the table. He violates the motion in limine. The judge sends the jury out, and then the judge says, and Stephanie Boyd, don't leave. And so I'm not trying. And the judge says, I want everybody in my chambers now. And I go back there and she's, you're not to leave. And I'm like, and it was funny because I think I had maybe been out practicing for 5 years. And I want to say, excuse me, this is not my case. I'm not listed on any of the paperwork. I'm just, sitting in the back in the gallery, not at the table. I wasn't even on the bench that's directly behind the attorney.
And you got right.
Yes. And I said, Okay. And then I stayed for the entire trial.
That is hilarious.
Yeah, but that's
Kinda
funny.
proud of it.
Oh. Can you mute us, please?
Hello, Mrs. Boyd, by the way.
He was an observation. He did not.
John?
Yeah, I don't see the AMP, so I will make it my business to go.
Yes. My mom always asks about you.
Oh, yeah. Although I guess it could be.
First page.
Fine.
And you can show it to Megan as well. Oh, but I need that back, of course.
Oh,
Yeah, yeah.
let me take a photo of it. I thought you were loaning it.
No, no. Well, here's the funny thing. Jamisa said she got it as an audiobook, but she said she's going to have to get it in hard copy because it's very stressful.
Oh, gosh.
If you have a Kindle reader, then
Yes.
you have a library card, you can download from the San Antonio Public Library for free to your
Oh.
But sometimes if it's a new popular book, there's wait lists and stuff.
Well, see, I cannot, my brother's got me Kindle. I have, I think, 2 or 3 Kindles from different relatives because I love to read. I'll take it when I'm on a trip or something, but I like to touch the books and smell the books. All right, can I have the parties on Raul Reyes? Court is calling 2022 CR 4920, State of Texas versus Raul Reyes. Can I have parties announced for the record for the state?
Ruben Rivera for the state.
Defense?
Megan Enriquez and John Coons for Raul Reyes.
Are you Mr. Reyes?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I believe I have received all the discovery that is currently in the state's possession, Your Honor, and I have reviewed it with my client.
All right, the court will find that the state is in compliance with discovery. Mr. Reyes, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you weigh the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the enhancement paragraphs and proceeding on count 1. Or, I'm sorry. Lesser included reckless injury to a child. Yeah.
Any objection?
No, Your Honor, that's our understanding.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand that the state is proceeding on the lesser included offense of injury to a child reckless? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, I did.
Counsel, has your client been able to provide you with any defenses?
Yes, he has lots of defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
I believe he is currently competent and was legally seen at the time of the offense.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, I did.
According to the plea, state is proceeding on the lesser included offense of injury to a child, bodily injury, reckless. They're asking that your punishment be assessed at 18 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney. Did you understand it and did you sign it in all the appropriate places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed and heard by the court. Did you understand?
Yes, ma'am.
And ruled upon. Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense of injury to a child reckless, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all of its attachments.
No objection, Your Honor.
Join you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, I'm thankful to my client for trusting me with his case, and I'm thankful to the state throughout our conferring and negotiations, and we just respectfully ask the court to follow this plea of bargain agreement that we've reached with the state.
All right.
And also that we also respectfully ask the court to grant him credit for all the time he has served in custody. I believe he has approximately, I think it's 216 days in the Bexar County Jail.
Okay. All right. And the court normally does not accept plea bargain agreements without good cause, or you have to plead open to the court. The court is going to find that there is good cause to accept this plea bargain agreement based upon the discussions that the court has had with the defense in the state, both being present and Mr. Reyes being present. All right, Mr. Reyes, is there anything you wish to say before the court passes judgment?
I know. I just want to thank my attorneys for really helping me with this case and just for giving me the chance to accept the plea bargain also.
All right, and what have you learned from this incident?
Not to lay down with dogs because you will get these.
But see, here's the thing. When you say not to lay down with dogs, the only people who lay down with dogs are dogs.
That's exactly what I mean, ma'am.
So you're not
gonna be a dog anymore, and I'm gonna stay away from other dogs. And I think I'm gonna stay away from a lot of people when I get out.
Let me tell you what you should have learned from this incident, from my reading this. Number one, you're an adult. This is a child. You can't play games with children that involve physical contact. There's a reason why when you see football games, they don't have young children playing with grown people. That's why you got the Pop Warner League, because those little children should not be playing football with adults. So in this case, it appears that you all were playing some sort of TikTok thing. And then this child hits you on the back of the head with talcum powder. And then you hit him and he hits a wall. You can't be playing violent games with children of this nature. You understand? That's what you should learn from this.
Yes, sir.
I was considering giving you less than 18 months, but I don't know if he's learned much from the statements he's made to the court. So I'm going to find you guilty.
Well, Judge,
Yes.
obviously.
All right.
Yeah,
John's coming
please.
in.
If you've opened that door a little bit, I, from our perspective, well, we've only known Raul for a few months now. He is he's made some mistakes in life, obviously, and he put himself in a bad situation. He definitely has learned from this situation. He is not someone that,
Never been violent.
this was an accident, quite frankly, from his perspective in terms of what happened. And when the police arrived at the scene, the mother immediately tells the police officer that her son was fine. She says he's okay. She says it several times. The kid had essentially no injuries. There's maybe even a tiny little bruise, but even that in the photos that were provided to us, you can't see anything. I think I understand that you might not be particularly happy with what Raul or how he just replied to you, but I do think his mother's been here for many of his court settings. She's a very nice woman. I know she raised him better than this, and he's unfortunately kind of made some bad choices in life, but his father's in failing health. He has a sister who has some health problems too. If there's any chance that you could show him any additional mercy, that would be wonderful.
All right. And then John Kunz, you stepped in, and now Brittany Mitchell stepping in.
Yes, Your Honor, and it's not for a reason you might think. I've been discussing with the mother of the victim. As the court knows, she is on probation. She wanted it to be known she's not here voluntarily. She is begging for me to drop the charges right now. And I told her that I would come and represent that to the court. But based on his history, the state feels that the 18 months is fair.
Okay. All right. Thank you so much.
Well, and yeah, briefly, Your Honor, I wasn't aware of that. And in light of that too, we'd ask that he get time served based on the time that he has served.
All right. Could I see the mother just briefly? Is she here?
Yes, Your Honor.
Can you just step to the side? Excuse me. Why out? I thought I had some up here, but I do not. Thank you. Is she here? Did she leave?
Are you gonna bring the jury?
Yes.
Okay.
Does anyone know where she is? Is she upstairs? Is she missing? Has she left the building? Just wondering.
Having been an advocate for how many years? Yeah, you've been there. You know.
All right, hasn't she been subpoenaed?
Was she subpoenaed, Travis?
So I think she was always telling us she would come, so I don't think we ever.
All right, well, tell them she needs to come into court. Yes, please.
I can go get her. Okay, we'll do that.
Thank you.
People with guns here, they can go get her.
No, we're not gonna do that.
Brittany's asking for a second while she's conferring. With the victim's, or the victim's mom.
Hello. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Sylvia Martinez Lopez.
All right. Now, I understand that you are on probation, so no one is going to ask you anything that will put you in any type of legal jeopardy. You understand?
Yes, ma'am.
All right. So I want to make something clear to you. And I want you to listen to me very clearly. And that's why I wanted you in here, and it's on the record. So with regards to any CPS case you have open, this is going to be on the record and anybody will be able to get it. Do you understand?
Yes.
This gentleman over here to my right, Mr. Reyes, you are not to have any contact with him. Do you understand?
Yes.
He is not to have any contact with the complainant in this case, which is your child. Do you understand?
Yes.
Now, I've read the police reports, and I know in the police report, you put in there, oh, I barely knew him. You and I both know that's not true. You are not to have contact with him. If he ends up at your house, whether he shows up on his own, if he does, you need to call the police. Or if he shows up because you've invited him into your house, Child Protective Services is going to know about it. Do you understand?
Yes, ma'am.
How old is your child?
11.
How many children do you have?
4.
What are their ages?
18, 17, 16.
Do they all live with you?
Yes, ma'am.
Right. And Child Protective Services is in your life, right?
No, ma'am.
Right. They're going to be in your life if you don't get your act together.
Yes.
And I know they were in your life previously.
Yes, ma'am.
I get so many parents when I was a defense attorney. You know what they would tell me when I would represent them in their CPS cases? They say, I'll walk through fire for my children. And you know what I would tell them? You don't need to walk through fire for your children. Nobody's asking you to do that. But what you have to do is you cannot be bringing people in their lives who should not be in their life.
Yes, ma'am.
People with criminal histories shouldn't be in your children's life because you're trying to set an example for them. And you know what they would tell me every time? Okay, Stephanie, I'll do what you say. I'm not going to get a new boyfriend. I'm not going to get pregnant during the pendency of this case because I want my children back and I'll do whatever I can to get my children back. And guess what they did? I would get their children back for them. You'd have this probationary period with CPS where they're still in your life. Next thing I know, I'm getting a call from the caseworker. And you know what they're telling me? Stephanie, your client is pregnant and she's moved some guy in here that she's met at the club on Friday and they don't leave. So, do you understand my instructions?
That's fine.
And I've read the police report. In the police report, it states that you said that your child did not suffer any major injury. Is that true?
Yes, ma'am.
And how is your child doing now?
He's doing good.
All right. And why are you letting them play this stupid game where they're putting talcum powder and he's hitting this gentleman on the back of the head? Why were you allowing that in your house?
I didn't know my son was going to do that. I didn't know.
Mm-hmm. You should not be allowing that. There is a reason. And while you were out, I told everybody this. There is a reason why you don't have children playing sports with adults because they can get injured. You don't see Pop Warner football team playing college players. You know why? Because they can get injured. Your children need to behave as children behave. And you shouldn't bring anybody in your house who's going to roughhouse them and hurt them in that way. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
Are they, so in other words, he is getting,
No, in other words,
because I mean, I wanted
the
to drop
thing.
the
the charges are not getting dropped. What you should be concentrating on is, instead of what's happening to him, you need to start putting your children first, and you're not.
No, I do put my children.
No, you do
first.
not.
Okay, ma'am.
Let me ask you this. If you put your children first, why are you letting somebody with his history come live at your house?
He wasn't living at my house.
Mhm.
No, he
But you
wasn't.
knew him, didn't you?
Yes, I did.
And
I
you
knew
told
him
the
and I met him
police
through
you
the mall.
barely knew him.
I met him
That's
through
what's in the
mall.
police report.
Okay.
You're not putting your children first. And if you don't put your children first, you know what's going to end up happening? You're going to have another CPS case, and you're going to have somebody else looking after your children, and who knows what will happen. Do you understand?
Yes, ma'am.
Any questions from anybody else?
None from the state, Your Honor.
Nothing from the defense, Judge.
All right, you're excused. All right, I'm finding you guilty. I'm going to sentence you to 13 months in the state jail facility, give you credit for any time served. There's to be no contact with Daniel Lopez and Sylvia Lopez. Do you understand?
Yes, ma'am.
And it would probably be in your best interest. Do not get involved with people who have children until you have your life in order. Do you understand?
Yes, ma'am. I understand.
And you're an adult. You should know better than to start playing these type of games with a young child. You understand?
Yes, ma'am.
And it is never appropriate in the situation that you were in to discipline somebody in anger, because it sounds like you were angry because he put talcum powder on his hand and then hit you at the back of the head. So that's not appropriate. You understand?
Can I say one thing here? No, I'm sorry. No, I wasn't.
There's a lot of no's going on from your counsel. I think it would probably be best for you to listen to them, because they went to law school and there's a reason they're telling you no. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, sir.
And I see there's a previous affirmative finding of family violence. With that, you're not allowed to own any weapons or ammunition. Do you understand?
Yes, sir.
All right. Good luck to you.
Thank you.
Thank you very
Welcome.
much, Judge.
All right. And attorneys, please remain. And Deputy Laura, when you get a chance, if you could bring the jurors in. No. Sure. Yeah, no, this is their. I don't have to memorize stuff. So he left, he ordered that. She's gonna go back.
Oh,
What I see is 2 miles.
Maybe. Oh, yeah. He's done it.
Yes, we're ready.
All right.
Oh, please be seated. All right, everyone, please be seated. So, ladies and gentlemen, I want to thank you so much for your service. I was not able to select the jury because we were in a jury trial already. So that's why Judge Nahara was doing jury selection. So we were going to have the jury trial today on Mr. Reyes. I know I instructed everyone to be here at 9:30, but there were some issues that we had come up. But I want you to know that your time was not wasted on your being here, because actually both the state and the defense were able to come to an agreement on this case that I approved of. So I thought to myself, do I let them continue to wait in the back and perhaps you will be done with your service for today? Or do I send you home and bring you back? So I thought that maybe you all would be okay with us keeping you in the back, maybe extra time, and then you will be done with your duty for today. So I hope I made the right choice for everybody. We do a lot of cases in this court. They're all felony cases. The attorneys on each side are very good attorneys. And so they were able to work things out. You're always welcome in the 187th District Court. We're here every day, and every day we do have a huge docket. I always, though, try to make sure that you know that your time is valuable and that we're not purposely having you come in at a specific time, then keeping you waiting. All right. Is there any questions from anyone? All right. So I want you to know there is a shortage of court reporters. I always tell jurors this, but there is an introductory course at St. Philip's College. So if you have someone who's just graduated high school and they want to take a gap year or find themselves, tell them to find themselves at St. Philip's College and they could potentially become a court reporter. Court reporters are paid very well. I have 3 degrees and the court reporter makes more than I do. So I put that out there because whenever I have the court reporter talk about it, they don't sell it very well. And people are just like, I don't want to do that. But it is a very lucrative career. And if maybe you're at home and you're thinking, heck, I could be in the legal field, but I really don't want to go to law school, or I want to do something different. I just want to listen and see what's going on. You too can be a court reporter. And whether or not you're a court reporter quickly or not so quickly really depends on your speed and accuracy. How many words do they have to get right, Deputy Laura?
255.
255, 275. Now, when I was growing up, we only had typewriters. And I started out on a manual typewriter. The young people know, John, you may know about manual typewriters. The young people don't know.
Yes, yes.
You know, thank you. Flipping that return carriage. And I really thought I was doing something when I would do the double space because you got a chance to hit it quick like you were going faster. And then we finally got the electric typewriters. But in my heyday, I could do probably 175 words a minute with no mistakes. So the fact that on this, you have to do 275 words and they tell me you're not typing the entire word. So I think people will be able to do that. The machines, though, are very expensive. They cost about $10,000, but the court reporters, if you call them, they will actually loan you some of their machines for you to practice on. And I have plenty of court reporters who are in training, come to my court, and they will take down everything. Of course, it's not official because we have our official court reporter, and they will take down everything. But does anybody have any questions? Now is the time to ask your questions.
May we ask what the determination of the court was in this case?
Yes. So anyway, from reading the police report, anybody objecting to me just telling them what the police. So this entire incident, what ended up happening is the defense's client was involved in a relationship with the complainant's mother. The defendant and complainant were playing some sort of TikTok game. And so the complainant put talcum powder in his hand and slammed the defendant in the back of the head. And then the defendant pushed the complainant, and the complainant hit his head, and he ended up with a bruise on his head. So that was the case. And so from reading that, what ended up happening is both parties agreed that he would be sentenced to 18 months in the state jail facility. He has been in custody now. So how much credit will he have?
About 216 days.
He has about 216 days credit. In this court, I try to make sure that people are not at the jail for long periods of time. But I need to make sure that both sides have their discovery, because nobody wants to go to trial and their attorney doesn't have what they need. So in this court, cases do move pretty quickly. So I know 216 days may seem long, but sometimes that has to do with them not being indicted yet. And I don't hear cases for jury trial until they're indicted. But once they're indicted, this court, I think both the state and the defense will tell you this court moves pretty quickly, but also making sure that everyone has their evidence. Any other questions? Yes.
Would it be okay if asked defense, they think that was?
Sure. Defense.
We do, yes, definitely.
He was a habitual offender, meaning a mandatory minimum 25 years in the penitentiary if he was convicted. So we didn't hear that one.
Mhm.
Yeah, y'all didn't know that.
That's you, and you weren't gonna hear that part. And so that we elected to go to the judge for punishment instead. God forbid he was convicted. We had some strategies in terms of hoping to prevent him from being convicted. But yeah, when you're looking at 25 to life and they offer you just a few more months in jail, it's hard to turn that down. So, yeah.
And
Very.
He's very happy, very
His
grateful.
mother has now left. She's an elderly mother. His dad's in the hospital, and his mother was in tears. She was very happy because she knew that if he were found guilty and it were minimum 25 years, she would never see him out of custody for the rest of her life. So it was a lot of pressure on us, because I built a relationship with the mother as well, who emailed me like 4 times a day, called me all the time. She's a friend of the office now, Daisy. So yes, we consider it a win. Thank you. But thank you for your time. Thank you all of y'all for participating yesterday. I know it was really hot in the other courtroom. I really appreciate your time and your interacting and your answers and your honesty and all of that.
And I will tell you, a lot of cases when somebody is indicted and they are a repeater or habitual because maybe they've been to prison before, normally you're not allowed to hear that because you're not really supposed to base whether somebody's guilty or not guilty on their history. You're supposed to look at this case and see what you would do with this specific case. And then afterwards, if they're found guilty, then you can look at the history and make a determination on punishment. Any other questions? Now is the time.
He was 9 at the time and he's now 11. 9-year-old boy.
And I did have the mother to come in so I could speak to her.
Was she happy with?
She did not want this case to go forward. Yes.
I'm sorry. Because of the fact that he was a boy, 9 years old, did that take any, in your minds, the demographics of us versus a girl, 9-year-old girl.
Well, and I tried to address that a little bit in jury selection, not the demographics at all, but, I know that, you know, he had a 2-month-old little girl. So obviously I was trying to make a point, like, obviously if you heard his 2-month-old little girl, that's gonna be much more egregious than a 9-year-old boy who's 5 feet tall, you know? So I was trying to make that point and talk about your cases first. It's any child, this charge is any child under 14. So, we did look if y'all had children or grandchildren on your juror cards and things like that. The baby powder slap challenge.
Apparently that's, you just put the powder on your hand and you slap somebody, I guess, and that's the whole thing.
And just FYI, the 9-year-old, he was a big 9-year-old. He was not like a
Right.
tiny little kid. I mean, he was a pretty good sized kid, quite frankly. So, yeah.
So just curious, I mean, for 2 years, we've utilized the legal system and came up to this. Would there have been a way to get this resolved much sooner without having to involve all these resources?
Isn't that a good
What I can tell you. All right, so I've been on both sides before. I've been a defense attorney and a prosecutor. When you think about it, the DA's office has hundreds, if not thousands of cases. And defense attorneys, it's not like The Good Wife, where you represent one client and that client is paying you $500,000. Usually you have a lot of clients to represent. And so sometimes you have cases that are on the front burner because you know this is specially set, it's going to trial, and you can't be present for 40 people at the same time. So sometimes it's, okay, this is now up, let's get this going. Now, what I can tell you is, as a prosecutor, sometimes when you're getting ready to indict a case, hopefully you look at everything and investigate it. But the problem with that is the prosecutors who are in this court, they didn't indict this case. Somebody else did. And when cases are indicted upstairs, they don't get to say, oh, this is the case I want that's been indicted. It's just random and on a rotation what case they get. And then when they have the case has already been indicted and they have to make decisions. And they're hoping that people have talked to the people that they needed to talk to, because you're not trying to reinvent the wheel.
Thank you.
Sure.
No, I know the defense was, you say you guys were happy with the judgment. How does the state feel about it?
I feel like it's fair, given the circumstances around the case. We were initially asking for a much higher deal, but push comes to shove, I think it ended up being fair for both sides.
Back to the timing and a bunch of factors. We just inherited this case from another attorney on March 28th of this year. So we haven't represented Mr. Reyes the whole 2 years. The off-run state was September 5th of 21. We've only been on it since March 28th of 23.
And since the defendant's mother did not want to move forward, was it the kid that wanted to keep pushing?
Yeah, so at the end of the day, it's really ours, and it's our decision at the end. So we figured that we had enough to move forward, even with their feelings. She still showed up today, but at the end of the day, I feel like it came to a fair outcome.
So it's not the father of the child.
It is not the father of the child.
And just so both parties know, so I used to do child protective services cases as well. And I've informed their client and I've informed this mother that part of my ruling is he's not to have any contact with her or the child. So he's not going to have any contact with them, and that's in the order.
And
Yes.
if he crosses the line, is that automatic?
Now, what will happen is if he has contact with her after he's served his sentence and Child Protective Services gets involved, they will see that I issued a no contact order and things will be done on the civil side. And that can happen if her parents were to call, because sometimes you have cases where people call the police and then the police get involved And there are cases that come to court, and then the people involved are saying, well, I don't want charges pressed. I want to withdraw that, which you're not allowed to do. So in this case, you have grandmothers, grandparents on either side who are looking out for the best interests of the children. So I know that if something were to happen where he to show up at her home, or she would have called him to show up, somebody would end up calling Child Protective Services, and they would see that there is an order from this court that there is to be no contact. And there's also an order from CPS court already that there's to be no contact.
And obviously, if he didn't have the criminal history that he had, we would definitely be going to trial. We think we could have, well, there's a good chance we could have won this trial, but when the stakes are so high and they offer a client something, and ultimately it's the client's decision whether or not to take, but he's thinking, okay, I can be out in a few months versus potentially 25-year minimum. You can understand so why a client would agree to something like that. So, and that's the unfortunate reality. And having known, the judge and I went to law school together, and we've been friends for a long time. And having been on both sides, I used to be a prosecutor myself. I've never been a judge, but when you have these scenarios, it's and for you guys who aren't involved in the meat and potatoes of it every day sort of thing, it's like, oh, well, why would that guy take 13 months in the penitentiary for something that juries, sometimes you can't predict what they're going to do. And we loved all of you guys yesterday. That's why you ended up on the jury. I think we were all very satisfied with all the jurors that we ended up with. But let me tell you, I've tried over 150 jury trials, both as a prosecutor and as a defense attorney. I've won trials I never should have won. I've lost trials I never should have lost on both sides. And you just can never predict it. And so again, when someone who's served time in prison before and stuff like that says, oh, wait, a few more months and I'm out and I'm done. Yeah. So.
And he had his intro ready yesterday. He would never get to deliver it.
What's that?
Remember you stopped him yesterday from giving his intro?
Yes.
Oh, yes.
Yes. Yes.
Well, yeah, he has a lot to say.
Yes. Yes.
Sorry, Judge.
Yeah.
You weren't there, but when we just said, good afternoon, this is our name, and he stood up and he said, I just want to think he was going to go, and we're like, no.
Yeah, please, now's not the time.
No statements,
Yeah.
sir.
Definitely yelling out in the future that if you speak up, you're gonna get chosen something.
No, usually I will tell you, usually the
Normally the
rules,
opposite, yeah.
it's the opposite usually. I always tell people, if you are very quiet, what ends up happening, and this only happens in this world, it doesn't happen outside of the legal system. What usually ends up happening, you're sitting with someone and you're trying to take notes on everybody to see who you think would be a good fit for the jury. And what it never fails, what it comes down to, somebody will say, wait a minute, do you have anything? Did juror number 5 say anything? No, I don't have anything. Do you have anything? Well, 6 says this. I guess we'll go with the person we don't know anything about. And that's what usually ends up happening. So I always tell people, if you're quiet, 9 times out of 10, you're going to be on the jury.
There are a couple of people on this jury right now that didn't say anything. So
Okay,
yeah.
who didn't say anything?
Yeah.
You see, so all the people, you know what, everybody, everybody who didn't say anything, raise your hand. Okay, so the only people, if you count the numbers, 1, 2, 3, 4, about 5 people said something. The rest of you all are there because you said nothing. But I will tell you this, you're like, yeah.
Can I ask?
Sure.
Are you like the one that speak?
Well, so we get reason, each side gets 10 people that they can strike for any reason. We don't like their haircut. We don't like, whatever. We don't like the way they look at our client, whatever. So sometimes it's not a matter of we like someone, it's we got to get rid of someone else. And you can imagine from our perspective, there are a few people that raised their hands that we could not have on the jury.
Well,
So, yeah, they would not have been open-minded about our client. So.
And then in this court, the reason why there are 14 of you, I always have 2 alternates because you never know what's going to happen during a trial. We've had some people who've been on our panel and sadly, there's been a death in the family or something else happened. And that's why we have alternates, so we can always move someone else into the seat. Any other questions?
So
For the silent people?
Sorry.
Go ahead. No, we're here for you.
You were a silent one.
Was your selection based anything off of previous, like you knew where we work, you knew like our background? Or was most of it done just from kind of,
It's kind of taken as like a whole package. Like we look at your answers, what you said when we were asking you questions, when we were all talking, and then we go back when we're going through and trying to see who we want to get rid of, who we want to keep. We'll then look like, oh, well, she works in this field or she has 5 kids. So you kind of take the whole package into effect and you eliminate or select people based on everything.
But kind of like John said, it's more who we didn't want
Yeah.
on our jury. And then y'all didn't say anything offensive. to us,
And we don't actually get to select, even though it's called jury selection, it's really jury elimination.
Right.
We don't actually get to say, hey, I like what he said, I like what he said, I like what she
We
said type stuff.
eliminate, yeah.
We're only eliminating people, and the people that haven't been eliminated are the ones that end up on the jury. So
Any other questions? Now is the time. You have great legal minds here.
thank you,
wouldn't have had him
guys.
testify, right?
What's that?
You wouldn't have had him testify.
Our client, no.
I would have put him in a headlock and prevented him from touching that. It would have been an ugly scene, but I would have done it. So it's like, you are not testifying.
Ultimately, it's their decision. We
Mhm.
can strategize about everything and we can advise him not to. Some clients are stubborn, but I think that he was on board with not testifying.
I've tried approximately 100 trials as a defense attorney and never once has my client testified. And I've won a lot of trials. So it's never, as a prosecutor, you learn that when the defendant testifies, if the case is here, the best you can hope for is the case is still here after he testifies. It normally gets a lot worse for you after, no matter how educated, no matter how smart, no matter how truthful a person is. These guys are paid to poke holes in the story and make them, look stupid or like liars or whatever sort of thing. And that's what I used to do as a prosecutor. She used to do as a prosecutor. And so, yeah, but testifying is essentially never a good idea.
And it's scary too to testify. Because if you think about it, you're up there, everybody's looking at you, judging you. And in your mind, probably as a defendant, you're thinking, oh my gosh, I hope I don't say anything wrong. And what are they thinking? And it's the same thing when complainants or victims testify. All of these things are probably racing through your head. And so it's very difficult. It's not easy. And you're in the hot seat and you're the only person up there and people are firing questions at you. Any other questions?
Thank you guys.
Sure,
very
the
much.
quiet
Yeah,
people.
Thank you.
Well, here are your final instructions. 1, you have a sheet of paper. That sheet of paper signifies that you served on a jury today. So you can do 1 or 2 things with that. You can donate the money that you're going to receive. And they have different organizations there. I always say CASA because it's for children, but there are plenty of other organizations you can donate it to if you wish. Otherwise, what will end up happening is you will receive a check in the mail, probably 2 or 3 months from now. And you will think, was this a scam? What happened? What is this? Is this a real check? Then you're going to remember the great time you had here in the 187, the great time with both attorneys. And you're going to say, oh, this is real. But seriously, when you receive the check, if you decide to receive it, you can always come back downtown, enjoy some time on the Riverwalk. It'll probably be enough money for at least for you to get, what's the name of my favorite thing? I can't pronounce it. Yes, I had that for the first time about 3 weeks ago. And I'm like, where has this been hiding all my life? It is so good. Deputy Laura will probably be able to direct you to the place that's around the corner. They have one called Texas Rose that has cucumbers and green chamoy and pickles. That's not my favorite. My favorite one is the regular one. Yes. So it's very good. They're trying to take me through the foods of San Antonio. I've been here since 1997 for law school.
94.
I mean permanently, John. Permanently.
She went straight from 3rd grade to law school. So she is quite a bit younger than I am. However,
But there are certain foods that I'd never had until recently. One of them was tamales. I think I hadn't eaten those though, because there was a fear involved. Because you see it, am I supposed to eat this wrap? What's going on here? But then once I learned how to eat it, I was bean and cheese. Where have you been all my life? It was just fabulous. So they're taking me, I had my first corn in the cup, a cup corn or whatever it's called. So they're taking me through my tasting.
Tell them.
Yes, I had churros for the first
Tell
time.
them where you're from, Judge.
All right. So I'm originally from Louisiana. So, I see somebody saying, oh, is that a good O?
I mean, I'm from Georgia, so it's a southern thing, and I know Louisiana a little.
Well, guess what? You're not going to be doing well in the SEC this season.
Back to back.
No, my other friend, Cornelius Cox, he is a Florida Gator. So LSU, of course, we're playing them later in the season, and we always bet a lunch on the game. And he's like, as long as we're not playing LSU at night and the game is close, we'll win because the refs will take it from you at night. I said, whatever. So we will see how we do. LSU has been doing great. Baseball.
Yeah.
Track and field.
Yeah. They've won everything.
Yeah. So basketball. If only we can get our men's basketball team to do something. They didn't even do anything with Shaquille O'Neal.
No,
Les Miles and his freak defense.
They
Yes.
didn't.
Texas is coming to see.
Oh, well, you know what? I'm going to see. I'm going to tell you what I told A&M. A&M came to the SEC because they were not being treated right. And I told them, look, SEC, we're family. We're going to beat you on Saturday, but we'll still invite you to the cookout. So Texas, you want to come? We're going to beat up on you, but we'll still invite you to the cookout.
Let me get some.
Speaking of that, you guys are adversaries here in the court, but outside of the court, are y'all friends with each other?
Oh, yeah.
Absolutely. Yeah, we deal with the same group of people. They deal with the same defense attorneys every day. We deal with the same prosecutors, and it's rare that we get crossways with prosecutors. I mean, it's every now and then you have to. You know, there are times when someone's being a jerk or something like that, and you have to, not these two at all. Not these two at all. Yeah.
I just came to the defense 3.5 years ago. So 3.5 years ago, I was on that side. I was a prosecutor in the DA's office.
And I will tell you, the courthouse in a little way is sort of like high school. Everybody knows everybody. And a majority of the people who are here all went to St. Mary's Law School. And John can always call my mother if he thinks I'm not doing something. And I'm like, what are you doing calling my mom in Louisiana? So a majority of all the attorneys has my mom's phone number. The deputies keep saying, I'm gonna call your mom and tell you to give us a lunch break. So everybody is very friendly with each other. Of course, when they go to jury trial, it's, they're fighting for their client, they're fighting for their side. But during breaks, everybody's very friendly. And sometimes clients don't understand why you're friendly with each other. And then once you explain to them, everybody knows everybody. Nobody's going to come in shouting at anyone. And we, in this court, we do a trial a week. And I've never had any of the attorneys to be other than polite to each other. And in my court, when people are doing objections, I always make them remain seated because it's hard to get angry when you can't stand up. So everybody stays seated. And once they start standing up, I say, no, just sit down. See, here's my mom now. I'm sorry, just a second. Hey, mom, let me give you a call right. Oh, mom, the jury says hi. Okay, I'll let them know, mom. ASAP. Bye, mom. Okay, so mom said she was calling about the lunch break thing, but the reason why she didn't call at 12 is because she was enjoying the conversation to see what everybody was
She's
talking
watching
about.
it on YouTube right now.
Right.
This is all on YouTube.
Yes.
So
And
yeah.
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 So I usually have, you guys are not shown. But the reason why I do the YouTube channel is because I'm hoping that the public will get educated on what we actually do here. And then sometimes I have attorneys or defendants who are in Austin or Houston, and I don't want them driving down here if they're going to end up getting a reset or if something is happening with their case that it's not a jury trial. And sometimes it saves on money for them. And then sometimes we will have people who are accused who can't take off from work anymore. And I don't want people to lose their jobs. So I will tell them, when is your lunch break at work? That's sometimes why we're working during lunch. When is your lunch break at work? We'll take up your case during your lunch hour. Just find a quiet place. And so I try to accommodate people that way and accommodate both sides when there's an issue with that. And sometimes we actually, if both parties agree, we'll have a witness by Zoom because maybe that witness is not in state. Maybe they can't get here. We've actually had experts by Zoom before because they're in Georgia and have them do it that way. All right. So yes.
I'm sorry.
No.
So is the YouTube channel open to public viewing?
Yes.
Is there information that we can get so that way we can maybe?
Sure. If you just go to YouTube and you type in Judge Stephanie Boyd, I'll pop up in the what is that? A red plaid dress my mom bought me. So I don't like shopping, so I don't shop for myself because I think it's just, I'm like, no, I don't feel like doing that. Yes. So yes, you're more than welcome to do that, or either you can come down. But I do encourage everybody, since you're already downtown, walk around the Riverwalk. I always wonder when people live in a certain city, do they realize how great it is? For example, I love traveling to Europe, and I just see people walking around the Eiffel Tower or the Louvre, and I want to tell them, do you realize how great this is? And so in San Antonio, I know people say, it's just water flowing, but the Riverwalk is great. And if you walk, there is shade. You can grab a sandwich or something and just eat. You get to see the ducks. It is so peaceful. You just want to say, woosah, and just zen out. So you all don't have to go back to work because you've been here for the whole day. Make sure you get your parking validated. The last thing you want to do is walk to where you park in this heat and then say curses and have to come back to get that validated. So make sure you get that validated. And remember, you're always welcome to come by here. If you want to, if some of you are teachers, I don't know what the occupations are, but if you ever want to bring some students down to court, you're more than welcome to bring them. And we'll make sure that the attorneys talk to them. They see the criminal side as well as the civil side, so they can get an idea of what they want to do. I think it's very important to expose children to different things. Yes.
There are two questions, one for the prosecutor, one for the defense of the side. Prosecution, what's the little symbol you have on your?
Oh, so it's just a little pin from the Bexar County District Attorney's Office.
Okay.
Can I get one?
Yeah.
So, and for defense, best spot for a snack or for lunch over here.
Ooh, walking.
I'm telling you, the Mangaladas place. I know I'm mispronouncing that.
Well, the Mangaladas, but there's not full food there. It's more like.
No, they have hot dogs.
Oh, they have hot dogs. Okay, well.
I mean, here.
Yeah, I do like hot dogs. I love hot dogs.
I would say Asanar, if you want
Asanar is
Mexican
good.
food, which is just on Houston Street here. And then also the Esquire Tavern, which is kind of cool. It has the longest bar in Texas or whatever, and it has pretty good food. They have lunch specials that everything downtown's expensive. I think lunch specials are $12.99, but that includes an iced tea and stuff. So it's good. So yeah, and that's only literally a block that way.
And then you have what's the burger place? Is it called Bonds? And so, but Bonds, their burgers are, I don't even know how people eat them when they're this high. You have to figure out how to eat it, but they are supposed to be world renowned or something. And there are a lot of places on Houston if you just walk. But I hope you guys will stay downtown longer and enjoy it. And you guys can have lunch with each other. If you all were on this jury, I would have ordered lunch for you guys if we were in a jury trial. Yeah.
I got time.
If only. But again, thank you all so much for being here. I really appreciate it. Thank you.